Good afternoon. My name is Gregg Nunziata, and welcome to the Society for the Rule of Law's webinar on impoundments and the congressional power of the purse. I am the executive director of the Society for the Rule of Law, and before we get started, I'd like to just tell you a little bit about us if you are new to our programming. The Society is an organization made up principally of conservative and libertarian lawyers who prioritize the defense of the Constitution, the rule of law, and American democracy above our partisan or policy priorities. We are a membership organization. Our membership makes this programming possible. If you're not currently a member, we invite you to become one. If you are a member, we suggest you invite a friend. Members do not need to be lawyers or conservatives. We welcome anyone who shares our values and support our work. We will have a link to join the Society in the chat right now. A couple of quick notes on upcoming programs. We have our next virtual event will be on May 6th, which is another webinar, and that's on free speech under the Trump administration. We will be joined by Keith Whittington, a charter member of the Society and a professor at Yale Law School, Professor Eugene Wallach, and Bob Kornrevier of FIRE, the Foundation for Individual Rights and Expression. Our next live event is going to be in Phoenix, Arizona, our first live event, I believe, outside of the DC area, certainly off the East Coast. And it will be a networking opportunity with a programming which will include a conversation between me and Arizona Supreme Court Justice Clint Wallach, about rule of law issues, the independence of the judiciary, and related concerns. Some of our recent updates from the work we've been doing here in Washington: a number of our members partnered with former January 6 prosecutors to file a complaint, professional responsibility complaint against acting U.S. Attorney Ed Martin here in the District of DC. The Institute, the Society for the Rule of Law Institute, our advocacy arm, has signed on to multiple amicus briefs defending law firms from the Trump administration executive orders. We will have links for all of that in the chat as well. At the end of our conversation, there'll be ample time for questions and answers. So please drop any questions you have in the chat. You do not need to wait till we start the Q&A. Just when a thought comes to you, please post it, and I will present them to our panelists as soon as I have the chance. With that, let me introduce the panel. We have Professor Zachary Price of the University of California, San Francisco College of Law. Professor Price focuses on constitutional law and constitutional questions generated by political polarization in our current moment. Billy Ford is a policy advocate at Protect Democracy, where his work focuses on legislative guardrails against abuses of executive power. Protect Democracy does a lot of great work, including on this specific issue of impoundment. PD has a recent report on the myth of presidential impoundment power. We will have the link for that in the chat. Dr. Philip Wallach is a senior fellow at the American Enterprise Institute, where he focuses on separation of powers and the relationship between Congress and the administrative state. We'll also have some links from recent publications by Professor Price and Professor Wallach in the chat. And that is it for our introduction. I'm excited to get this conversation started. Gentlemen, thank you, all three of you, for spending your time with us today. This is an important issue, which I care a lot about. Impoundment sounds somewhat esoteric, so it'll be useful to explain all this to our folks. Of course, the congressional power of the purse is one of its primary functions, one of Congress's kind of chief powers, and maybe there's this idea that that's one of the powers that Congress is least eager to give up, but maybe not in our current moment. So I would love to hear your perspectives on this and the legal, historical, and kind of political background of what we're looking at during the Trump administration on impoundment. So with that, Professor Price, please.
All right, well, thanks very much, Greg. First of all, let me just thank you and the Society for having me. It's great to be part of this event. So I think the plan here is that I'm going to talk pretty generally about impoundment, what it is, what the law says about it, whether there's a constitutional authority to impound, and then Billy is going to talk about some of the history, and Philip will talk about some current issues. So just to kick things off, what is impoundment? People probably are now familiar with this term, but the basic idea is it's a fancy way of saying that the executive branch is refusing to spend money that Congress has required it by law to spend. So Congress has appropriated funds using that power of the purse, required it to be spent. Executive branch is not doing that. So since 1974, impoundment has basically been unlawful. Before then, I think it was sometimes unclear whether spending was mandatory, required digging into the details of particular laws. That creates some confusion about historical examples that Billy will talk about. But in 1974, after President Nixon attempted some very large and controversial impoundments, Congress enacted a law called the Impoundment Control Act. And that law establishes a ground rule. Basically, the executive officials need to spend money that Congress has appropriated for the purposes that Congress has prescribed. So it basically severely limits impoundments. More specifically, it says if the president wants to rescind money, wants to cancel funds and appropriation, he can't do that on his own, has to propose legislation to Congress, and then he can pause the spending for 45 days while Congress considers the legislation. But if Congress doesn't act on the proposal, he has to go ahead and spend the money. The law also says administration can't even defer, that is, delay money within a fiscal year, except for, well, first of all, it can only do it for kind of non-policy reasons, programmatic reasons, and even then is supposed to report it to Congress. So that's the basic structure, really limits presidential authority to impound funds. Now, there's still often a lot of discretion built into appropriations themselves. Often how money is spent, what particular uses it's put to is a matter of executive discretion. Sometimes whether to spend money at all is discretionary. You have to look at each particular program to be sure. But the Impoundment Control Act puts these kind of background rules into the structure so that in general, if money is appropriated, it's not optional to spend it. Okay, so that's the basic kind of what impoundment is and what the current legal structure is. So then that raises the question of whether those types of constraints are constitutional. Can Congress require the executive branch to spend money in this way, or does the president have a prerogative not to spend money even when Congress mandates it? So the administration, so far as I know, hasn't squarely made the argument in court that the Impoundment Control Act is unconstitutional. But President Trump, at least as a candidate, suggested that. Some key figures in his administration made this argument on some reports last summer. So that it's in the background, it's in the air, and then at the same time, the administration has done a lot of pausing and delaying and cutting, as folks are probably aware. And again, you have to look at the details of each program to know whether that's lawful or not. But I think it's hard to say that all of it is compliant with the Impoundment Control Act. So is there a constitutional argument for impounding funds despite these constraints? I think the answer is no. I think impounding funds is unlawful. I think we just run through the kind of conventional considerations and constitutional interpretation. I actually don't think it's a terribly hard issue. I think they all kind of cut against the administration's position. In terms of the text, the Constitution pretty squarely assigns power over government expenditures, the so-called power of the purse, to Congress. It specifically says no money should be drawn for the Treasury, but in consequence of appropriations made by law, that means the government can't spend money unless there's a law specifically providing the funds. Now, of course, impoundment involves the opposite action, not spending money. But there, the Constitution gives Congress the power to spend money for general welfare, to enact laws necessary and proper to carrying out other government functions. And then it says in Article 2 that the president has a duty to take care of the laws are faithfully executed. So I think that means carrying out statutory obligations is not a choice. It's a duty for the president, and that includes laws requiring money to be spent for some purpose. I think looking beyond the text, this power of the purse is very important structurally. It gives Congress an ongoing say in how executive powers are exercised. I think that's something that's particularly important given the breadth of delegations that have been made to the executive branch over time. So I think it's structurally important. In terms of original meaning, the framers thought this power over money was a central legislative authority and a really key feature of separation of powers. And then in terms of case law, the Supreme Court upheld a payment mandate back in 1838, in this case called Kendall versus United States. It said basically that the president is obligated to faithfully execute the law. It turns that on its head to say he can refuse to spend money when the law requires it. More recently, there was a 1975 case called Train versus City of New York that came out of the Nixon impoundments. The Supreme Court, again, required the expenditures the administration wasn't making. It didn't address constitutional arguments because the administration had abandoned them, but it also didn't suggest there was any particular problem. In a later separate opinion, Justice Scalia referred to Nixon as the, quote, Mahatma Gandhi of all impounders, but characterized the decision in Train as proving him wrong. So the case law is against the view that there's an impoundment prerogative as well. And then also I think the historical practice really doesn't support this idea, as Billy will talk about. So I think that's the basic case against impoundment authority. And I don't think it's particularly close issue. Again, the details will be complicated in each particular case, but I think the background framework is pretty clear. So I guess just to add a last couple thoughts, I mean, where is this coming from? Why would the administration take a different view? Let me just mention briefly, I mean, they do have a constitutional argument that's very weak. They also have kind of a practical concern, and then there's a kind of political context that's worth highlighting. So I think their constitutional argument, to rebut what I just said, is essentially that declining to spend funds or kind of discretion over funds is part of the executive power that the Constitution vests in the president, and also an aspect of deciding how to faithfully execute the law. I would say this is the kind of conventional Article 2 Hail Mary. If you want to say the president has power to do something, it's part of the executive power. The president can do whatever he wants. That has some force in context where the Constitution is more ambiguous, but I think it really shouldn't carry much weight here, given the more specific considerations I talked about. So I think that's their constitutional perspective. In terms of practical concerns, I think they would say that giving Congress this degree of authority over spending, in particular the power to require spending, as the Impoundment Control Act does, I think they would say it just leads to a lot of inefficiency and waste. And this is an argument that does have a long history. People made this argument back in the early 20th century as a reason to give the president a bigger role in budgeting. It came up, Nixon made it, came up in the Reagan era. So it's an argument that keeps popping up. I don't know if it's true. I mean, there may be something to it, but I don't think it should override more specific constitutional considerations. But then more generally, I mean, it's sort of wrapped up in an idea that the president is a better representative of the overall national interest than Congress. Congress wants to fund specific things, and the president speaks for the whole country. That's always the way this argument has been made historically, and I that may have had force. I mean, again, there's something to it, but I think it's hard to view President Trump as a great embodiment of that idea, given how close the election was, how controversial much of what he's doing is. So that brings me to the final point, which is the kind of political context. And I think the specific position Trump has taken on impoundments is pretty novel. Recent presidents have not, no president has really made this argument since 1974, just arguably apart from Nixon, even before that. But it does fit in a pattern that's been a feature of our era of polarized politics, which is that presidents get elected with narrow majorities. They represent ideological parties with strong policy platforms, and they run into the fact that our constitutional system is designed to make big change at the federal level difficult. Legislation is hard to enact. I think that's a deliberate design choice by the framers that I think is pretty wise. In a big, diverse polity, to make big changes should require strong political support, but it leads to frustration for presidents. And so they look for ways to achieve their goals with inventive executive power theories instead. And this very much fits within that pattern. Trump has taken that type of approach to a real extreme, not only with impoundments, but in other areas. But I think it's a very destructive tendency. And I hope, we can see that before it gets further out of hand. So anyway, that's my basic take on impoundments, but I'm really looking forward to the discussion and to what the other panelists have to say.
Thank you, Zach. Now, next, Billy.
Thanks, Greg. I'm just going to share my screen here, if you give me a moment. Excellent. Can you all see the slides? Wonderful. Yep. Well, so thank you to Greg and the Society for the opportunity to speak today. Thank you, Zach, for kicking us off with that background on the legal and constitutional issues here. I think you teed up very clearly why, as a matter of text, structure, and case law, it's not quite a close question about whether the president has an inherent power to impound appropriated funds. But we're going to talk about the thing that comes after those three, which is historical practice. And as Zach alluded to in his remarks, some of the president's senior advisors, including OMB Director Russell Vogt and OMB General Counsel Mark Palletta, have been arguing since June and September of 2024 that the president has this inherent power to spend less than the amount Congress appropriated, even if Congress has directed otherwise. And they specifically argue that historical practice from the founding through the Nixon administration bears out this theory. During that period, they argue that presidents routinely impounded funds that Congress appropriated. Congress largely accepted this practice, and the unbroken nature of this practice over time supports this notion that the president doesn't have to spend the full amount appropriated. This characterization of the history, in our view, is wrong. My organization, Protect Democracy, recently put out a paper that Greg mentioned earlier, diving deep into this history. And showing that it in fact does not support it does not support the arguments that Palletta and Vogt have been advancing. But before turning to some of these findings, I want to just step back and talk about how courts typically consider and evaluate arguments about the scope of executive power that are based on historical practice. These arguments often arise in separation of powers cases, and the courts have set a pretty high bar that needs to be cleared for accepting historical evidence as a gloss on the executive power. Justice Frankfurter's concurrence in the Youngstown case, which you see on the slide here, sets out the canonical standard for how courts should consider this evidence. And he wrote that a systematic, unbroken executive practice, long pursued to the knowledge of the Congress and never before questioned, engaged in by presidents who have also sworn to uphold the Constitution, making, as it were, such exercise of power a part of the structure of our government, may be treated as a gloss on executive power vested in the president by Section 1 of Article 2. So to shorten that a little bit, for a practice to be considered a gloss on the executive power, it needs to be systematic, unbroken, and never before questioned. And just to be clear about the practice that we're talking about here, it's a practice of defying Congress's appropriations laws, of spending less than the full amount when Congress has required or directed expenditure otherwise. So in short, the bar that proponents of this impoundment power need to clear is that presidents have systematically defied congressional directives to spend, that this practice has been unbroken, and that Congress and the courts have never questioned it. It's both a very high bar to clear and one that the historical record just doesn't quite support. And so I want to note that the first part of this conversation here is going to talk about impoundments before the Impoundment Control Act, before this sort of across-the-board requirement that Zach discussed, that presidents can't spend less than the full amount Congress appropriated unless they follow the procedures specifically set out in that law. So in reviewing a number of historical instances of impoundment, all of the instances that Paletta and Vogt sort of cataloged in a paper that they published last summer, we found that in the overwhelming majority of cases, when Congress spent less than the full amount appropriated, they did so pursuant to discretion that Congress wrote into statutes rather than in defiance of a statutory directive to spend. And so what we have on the screen here is one of the sort of famous early examples of a presidential impoundment. This is President Jefferson's temporary impoundment of funds that Congress had appropriated for the construction of gunboats. And if we take a look at the appropriations language here, which is what I've sort of screenshotted and included on this slide, you see that Congress authorized the construction of a number not exceeding 15 gunboats using a sum not exceeding $50,000. So there's this clear sort of grant of discretion that's written into the statute such that Jefferson can decide how much of the money to spend and how many of the gunboats to build. We found in our review of impoundments from the founding through 1974, the majority of the cited instances where presidents were spending less than the full amount appropriated were pursuant to these kind of grants of discretion. But there were instances where presidents did defy Congress. And we found that those two tended to fall into, that there were a few trends that you could pull out from that. One of those trends is that where presidents defied Congress, they at times offered a statutory rather than a constitutional justification for the action. So back in 1876, Congress enacted a river and harbors appropriations bill. President Grant decided that he didn't want to spend some of that money. And when Congress pressed the Secretary of War, who was responsible for executing the appropriations, to justify the under expenditure, the Secretary came back and said, hey, quote, the law and authority for us to spend less than the full amount that you appropriated is, quote, found in the act itself. So it was an attempt to justify on statutory rather than on constitutional grounds a decision not to spend appropriated funds. And then in other instances where presidents defied a congressional directive to spend, you see considerable pushback from both Congress and the courts. Zach already covered Kendall, so I won't go back through that, but that was a clear and very early rejection of the notion that the Take Care Clause gives the president, constitutional power to decline to execute a spending law. During the Roosevelt administration, about 100 years later, when Roosevelt was impounding funds that Congress had appropriated for programs the president deemed non-essential to the war effort, and Roosevelt withheld, substantial sums of that money, he faced considerable pushback from Congress in hearings, in floor statements and speeches, in legislation. And then later, when President Nixon was impounding billions of dollars in funds for domestic programs, he faced just a thicket of litigation in the district court cases where he expressly raised a constitutional justification for the actions that he took. The courts that considered those cases uniformly rejected that constitutional argument. So what we see from this pre-1974 period is not an unbroken and unquestioned practice of presidents impounding funds in defiance of Congress. But in many instances, presidents spending less than the full amount appropriated because the statute that Congress enacted gave them the authority to do that. Or if the president defied Congress, there were just these various avenues of pushback against the action taken and the power asserted. And then I want to make sure that we're not sort of forgetting the history after 1974. And this builds on a point that Zach has made in a prior piece, that what matters for considering whether there is historical practice supporting an inherent presidential power to impound is not just what happened before the Impoundment Control Act, but also what happened after. And of course, presidents have not complied perfectly with the Impoundment Control Act. There have been some notable instances of presidential non-compliance in the years since 1974, but overwhelmingly, presidents of both parties, including those who took a very broad view of executive power, overwhelmingly have complied with the Impoundment Control Act. And as Zach mentioned, none of those presidents, to include President Trump in his first term, asserted an inherent authority to impound funds in defiance of Congress. So this is just a brief historical snapshot, but I figured that's what I would start us off with. So I'll turn it back to you, Greg.
Great, thanks, Billy. Very helpful. Appreciate it, Phil.
All right. Well, thanks for having me. This has been really educational so far. I'm going to try to give us an update on sort of where things stand in April 2025, and a little bit of perspective on where Congress fits into this whole picture, because I do think when we're talking about basically trying to protect Congress's power of the purse, Congress deciding to vindicate their own constitutional power is probably the most powerful thing that could repudiate what the administration is doing, and something we have basically not seen to this point. So we'll talk about why that is. But first, let's just talk about where the administration is on impoundment. As Billy said, there is this very clearly argued paper from Mark Paoletta and some co-authors that was put out last year, making the case that there is a constitutional impoundment power. But since he's entered the administration, I think it's pretty clear that Russell Vogt, the OMB director, also sympathizes with that position, but they have not made that the official administration policy in any kind of straightforward way. They have not come out and said, okay, well, we're doing impoundments. That's not been their MO. And frankly, the Trump 47 administrations does not put a great premium on legal precision in general, right? A lot of times they're saying, cut this, cut that, and the sort of exact, precise formal mechanism by which it's happening is often quite obscure. And I think to elaborate on that, I think it's necessary that we bring Elon Musk and the Department of Government Efficiency into this conversation. What is Doge? It's not the easiest thing to say, even if you've thought about it, the question, for many hours. In some ways, it's a brand name for cutting government activities within this second Trump administration. Organizationally, Elon Musk has no power. De facto, it's clear that he has quite a bit. That makes things confusing. Organizationally, Doge is the converted remnant of this digital service created by the Obama administration, but it also seems to have sort of affiliate members embedded in different agencies. And if they're the ones making the operative decisions, then in some ways it's the agency itself taking the action, not Doge, the actual organization. So all this gets pretty confusing, and there is sort of a sense in which the de facto reality is going around the sort of constitutionally required appointment process. So that leaves us all in kind of a thicket. But in any case, Doge is the brand name put on a lot of the actions where we're doing something like impoundment, where we're stopping money from going out the door that seemed like it was legally obligated. And now I think it's worth saying terminating contracts or grants is not impoundment. There's a whole different set of rules and regulations. The federal acquisitions regulations constitute a whole body of law unto themselves. That's not to say that everything the Trump administration has done on those fronts is legal. I think there's a lot of challenges that may have some force to them, but I don't think that's impoundment. And so it's sort of a separate channel. Shuttering agencies, well, is that impoundment? It starts to look like it if you have Congress appropriating money to a bunch of programs administered by an agency, and then you shut the agency down such that there's no way that program is going forward anymore. And yet there's sort of some amount of executive ability to reorganize Congress has granted more substantial reorganization powers in the past that the president does not have today. But in any case, you can sort of make some administration arguments about how, oh, well, we're just sort of changing where this department sits, and that's not an impoundment. So I think that's another place where, again, the sort of ambiguity surrounding a lot of these actions means it's, I think there are people making Impoundment Control Act claims against many of these cuts. By my count, there were 14 lawsuits in the Just Security Litigation Tracker that cited the Impoundment Control Act. And some of them have led to temporary restraining orders, sort of telling the administration it cannot stop funds. But those are very much active litigation. We don't know how that's all going to shake out. And I think a lot of the question will be, how much do the courts actually see these particular actions as impoundments? I think Zachary and Billy are right that the constitutional case law is very much unfavorable to impoundment, but maybe it would be more unfavorable to some of these gray areas where it's not quite impoundment, and you can make some kind of executive branch authority argument for doing something less than impoundment. Let me then turn to Congress. Because really, I think it's worth saying, if you had some instance where Congress mandated go accomplish X, and here are X dollars to do it, and it didn't build any flexibility on the X dollars into the statute, but then the president said, well, I accomplished the goal with spending X minus $50 million. Isn't that great? It really is pretty hard to say that that would be a grave offense against the rule of law, or that anyone would get too bent out of shape about it. I think you would find ways of taking that money and doing something else with it, or doing a rescission. The rescission, that's the technical term for Congress passing a law that takes previously appropriated money and brings it back into the Treasury. So that's the sort of prescribed channel that the Impoundment Control Act created in 1974, and has not been a great success in practice. In any case, I think it's worth saying that ultimately, if we're thinking about who's going to protect Congress's power of the purse, the courts can do a certain amount. They struck down the line item veto that Congress tried to give the president in the 1990s. And by striking down some of these actions in the Trump administration, they could sort of strike a blow for the forcefulness of appropriations law. But ultimately, if Congress is just sort of sitting there saying, well, we actually like what the administration is doing, I think that's going to make it difficult to turn this into a really powerful issue against them. And so why has Congress, Republicans in Congress, mostly been not too bent out of shape about this? I think there's some exceptions. But I think it's an important point. The appropriations and budget and authorizations processes are all in bad shape in Congress. And when we think about why is the Speaker of the House, Mike Johnson, when he hears about DOJ's work, he just says, yeah, this is great. Congress can't get this work done. The Biden administration stonewalled us, so we couldn't get the administration we couldn't get the information we needed to do this efficiency work, but now you can, and that's terrific. And the chairman of the Appropriations Committee, Tom Cole, pretty much saying, yeah, maybe Congress isn't really doing its job. Well, I think we have to appreciate that even though appropriations laws get big bipartisan majorities to pass them, it's like the legislators don't really mean it. They're not really very invested in the spending, and the authorizations process, which is supposed to be where committees do the hard work of sort of scrutinizing programs and taking ownership for what's going on in the government, in many cases is just defunct. Like USAID has not been authorized for many years now, and so when Republican members of Congress see USAID being basically shut down through executive action, and they just say, well, yeah, we kind of thought that program was corrupt, even though we were funding it. That shows you that something is going wrong with the way our spending process is working. And so, ultimately, Congress thinking of itself as broken and endorsing ways of circumventing its own spending laws is a pretty distressing situation. But that is where we are today. And if we really wanted to see the Impoundment Control Act work the way it's supposed to work, in some ways you need to get the spending process working the way it ought to work, where Congress is actually taking ownership of things. So I could go on, but I think let's go to the discussion.
Yeah, great. Thank you, Phil. I appreciate that. Maybe first, just give everybody a chance to chime in if thoughts arose during your colleagues' presentations. Zach, did you want to follow up on anything that's been said?
I think I could just go to the questions, actually.
Okay.
I thought of one extra thing. Just let me say something about rescissions. Elon Musk sat down with a meeting of senators and was told about rescissions and said, "Oh, wow, that's great. We can do that." Apparently, he just did not know that was an option on the table. So rescissions do have the advantage of being able to go through the Senate on a bare majority vote. I think, from my perspective, if Congress wanted to start voting on rescissions packages submitted by the administration, that would be a very positive development. It would show Congress taking ownership. And if they want to vote to stop spending, then fine. That makes the legislators responsible for that decision. It kind of puts things where they ought to be. Now, whether this actually comes to pass, we have to see.
Yeah, actually, one thought along those lines. So in terms of the dynamics Phil was talking about, there's also a pattern here of the way the levels of partisanship tend to make Congress either over or under protective of its institutional interests. And so right now you've got unified party control, and that tends to make Congress very weak about protecting its long-term institutional interest in protecting its power of the purse, because it either likes what the president is doing or doesn't want to, be kind of inflict political damage on itself or risk a primary or something if they cross him. So they're not likely to put up a lot of resistance. On the other hand, if Democrats win one or the other house in the midterms, then you're likely to see really acute conflict over these issues. And that's when the administration might need to resort to constitutional arguments and that sort of thing. So, it'd be better if we had a process that, was more functional and more balanced, but we tend to swing between either kind of too little checking or too much checking with respect to executive actions.
Yeah, it's interesting. You always hear that Congress is giving away its power because of because of fear. Legislating is hard. You get blamed for things. Legislation always involves compromise. But you would think that the spending piece would be the one piece they'd be most protective of. I mean, that is, at least in theory, kind of giving away goodies. That you're benefiting your constituents in some way, but it seems to not be the case. Can you? I don't know who's best to answer this, but maybe we can step back and just explain again how congressional spending is supposed to work. Despite myself working in Congress for over a dozen years, I actually never worked on appropriations. So maybe I could use a refresher too. Explain what is an authorization, what is an appropriation, and how does this how is it supposed to work, and how has it broken down? Is that a question for Billy or Phil? Who would be best to tackle that?
I'm happy to give him my best shot. So, we first of all have a budget process that sets out a plan that's supposed to sort of be where Congress takes responsibility for the big picture. That is now totally broken down and used only to secure access to this budget reconciliation process that lets you proceed without a Senate filibuster. I think it's fair to say that, there is no systematic long-term thinking happening in the budgeting process anymore, which is, it's the Congressional Budget and Impoundment Control Act of 1974. And I think it's fair to say that the whole sort of objective of that act, looked kind of reasonably fulfilled for a couple decades after the law's passage. and we got a balanced budget in the late 1990s, and in the 21st century, it's kind of gone off the rails pretty badly. Now, authorizations, you're supposed to have committees of jurisdiction doing authorizations for every single government spending program. And, you know, those are sort of periodic. They do it for X number of years, and then they need to do a reauthorization. And by rule, you're not supposed to do any appropriations for unauthorized programs, except Congress can waive its own rules whenever it wants to. And so in practice, authorization is just not mostly ignored. You know, we still have a National Defense Authorization Act, which is a big deal. It's one of the most important pieces of legislation Congress passes every year. But there's an awful lot of them that aren't on current authorizations anymore, and that are just running on Congress's willingness to ignore its own rules. And again, that just means, you know, this is something getting tossed into a big appropriations bill at the end of a year. That's how we mostly are doing appropriations for the last decade. And it may mean that the members are not really all that invested in the particulars. You know, that process by which they are supposed to take ownership has really broken down.
I would just add to that quickly, in terms of what a sort of standard appropriations process of maybe a fully functional time would look like. The president would send, you know, his annual budget request to Congress. The appropriations committees, and particularly the appropriations subcommittees, starting in the House, review that request, develop bills, pass those bills on an individual basis. And what you would have instead of an omnibus is individual subcommittees working on the bills in their jurisdiction and clearing probably, I think the number is 12 bills that would then go over to the Senate for consideration. And so it would be a process, you know, informed by the president's budget, but not necessarily, you know, the appropriations committees, of course, can add, subtract, and, you know, do whatever work they think should be done to those programs. But you would have individual bills for individual consideration rather than a full up or down vote on whether to fund the government, you know, that we've been seeing more and more in recent years.
Billy, how do you explain to people why they should care? I mean, I think I hear from a lot of folks, maybe it's just I travel in small government supporting circles. People have some enthusiasm about this idea that whether it's DOGE or some other mechanism, that the Trump administration is getting rid of waste, fraud, and abuse, or finally shrinking the government and closing down agencies that have been hard to close down, that Republicans have wanted to close down for a long time. So why should people, maybe particularly conservatives or advocates of small government, care about impoundments?
It's a good question, and I think it comes down to the rule of law and whether a single person should have the power, or we should think that a single person should have the power to decide whether to follow a law that Congress has enacted. I think there are reasonable people can disagree about the appropriate level to fund programs, and I think it is a valid view to believe that there should be less government funding, government spending, and not more. But I think the problem is that if a single person gets to decide that, then, you know, what program is executed and funded and which are not sort of rise and fall on one person's whim. And I think that's too much power to give to a single person. And also, while one might like how one president exercises that power, you could imagine a program that you know, Republican senators and representatives worked hard to enact and fund that a future Democratic president would decide, you know, he or she doesn't want to support, and could decide not to fund if we sort of accept that the president has this power just not to follow appropriations laws if they don't want to.
Zach, Phil kind of raised this before, but how do you think about it legally or constitutionally, the difference between a president using impoundment to try to frustrate the will of Congress versus, you know, legitimately finding savings and not spending every last dollar? Do we think about that differently from a structural perspective, and how do you draw the line even?
Yeah, I think you certainly could have situations where you're able to fully, faithfully execute the law without spending the entire amount that Congress made available for it. And, you know, it certainly wouldn't raise the structural concerns that I was addressing. I should know this, but I believe that if that scenario is in place, I think that's not necessarily understood to be an impoundment. But the trouble is that a lot of the way the government works isn't really structured quite like that. Instead, over time, we've conferred these really broad authorities on executive agencies. And then what Congress does is it kind of controls the level of resources that's available to carry out those functions. And so from that point of view, the executive branch has a lot of power of initiative in sort of setting policy, setting priorities, and it's through the control over the funding that Congress exercises a check. That's arguably a kind of inversion of the way the constitutional design is supposed to work. It should be Congress kind of setting the policy and the executive branch figuring out how to carry it out. But for a long time, we've sort of flipped that around through a lot of delegation. But in that context, I think it's really important to have some check, and that comes through the appropriations process. And Congress often will do things like say, you get no money to enforce this regulation that we don't like. That's how it exercises a control on executive policies. And I think the flip side can be just as important. If the president doesn't think some regulatory program is important, but Congress does, being able to require that a certain sum be spent on that purpose is an important way of controlling that sort of unilateral executive action and creating a more stable governance system over time.
Thank you. And we've got a few questions. I encourage folks who have questions to drop them in the chat. But this is a question for Phil. You talked about how the appropriations process, the budget process, is broken down. Do you have any practical suggestions or tips for how to start fixing this problem?
Yeah, well, the omnibus tendency has gotten out of control. It's almost like a joke to the members on the Hill how they just expect the leaders to jam them up against the Christmas holiday as a way to get the leverage to get them to sign on to some kind of big omnibus spending bill. And that's become the real budget process, the real appropriations process, even if we still hypothetically imagine that we're going to pass 12 individual subject-specific bills. So, for me, I see it as sort of part and parcel of this overly centralized, leadership-dominated Congress, which applies to both chambers at this point. And I think you actually just have to get back to the process of getting the two chambers to go to conference or something on particular bill. We're in this pattern where the House passes appropriations bills in the summer, but they're not sort of serious efforts at coming up with what the kind of thing is that you can get a big bipartisan majority in support of. They're sort of partisan exercises. So I don't know. I think appropriators themselves, used to be thought there were three parties on Capitol Hill: Democrats, Republicans, and appropriators, and they were sort of thought to have their own concerns and their own sort of jealousy of their prerogatives, and I think that's eroded to some extent. It would be healthy to see them try to reassert that. Again, you have to do that. You have to get a little bit of distance from the leadership, and not just sort of see yourself first and foremost as allies of the leadership. And that's where we are. That's where we are today. So I don't expect any. Congress literally chose to just punt on their appropriations for fiscal year 25 by passing a full year continuing resolution. They seem to want to take as little responsibility as possible in that appropriations process. So we're kind of at at a nadir for congressional responsibility taking on fiscal matters. And yeah, certainly Zachary is right to emphasize that if we saw a Democratic House come in 2027, that would look very different.
There had been some interest on, I suppose, mostly with Democrats, but a bit on the right too, about restoring or returning to earmarks, and there's been some of that. Has that played any role in congressional ownership? I mean, the idea was that if we brought back earmarks, congressmen and senators might feel more ownership in the spending process. Has that happened?
It's come back kind of under the radar, because if they call it was it congressionally directed spending or something, they don't want to use the word earmark. It sounds dirty. I think it has helped people get buy-in a little bit, but the dynamic that creates is just, okay, well, I've got my earmarks, I want to make sure the president doesn't cut them. And in some ways, Representative Tom Cole, the appropriations chairman, said, oh, well, I didn't like the way DOJ was threatening some Oklahoma project, so I talked to them and they stopped. Well, that's great, but that's sort of that's the dynamic that can get encouraged there, a very sort of parochial court politics, rather than, again, big picture, like Congress taking responsibility kind of politics.
Zach, one of our questions is shuttering an agency would be an unlawful impoundment, but the questioner notes that reorganizing the executive branch is also congressional legislative power. Do we think that Trump-led or DOJ-led reorganization would face skepticism at the Supreme Court?
Yeah, so that's certainly correct in general. I mean, Congress has the authority to create and design agencies and allocate authorities to different officials. I think that's a really important constraint on the executive branch. And I have wondered from that point of view how whether a lot of what's being done is lawful. It depends on what is in the statutes and what's just been done executively and implementing them. There are also, I don't know the details off the top of my head. I mean, there are sometimes reorganization authorities that the executive branch has, but it has to go through certain steps and reporting them to Congress and so forth. And I'm not sure that's being followed. So I think one could imagine them losing a case, but I think that there is with appropriations and with these sort of organizational issues, I think a big problem is that you start to run up against the limits of what courts can do very effectively. Courts tend not to. Courts don't want to be running agencies. They don't view the kind of programmatic aspect of administration as their job. What they're good at is resolving, discrete legal issues, questions of authority, and so forth. And so when you get into these programmatic things, like, are you distributing grant funding in good faith? Are you, properly carrying out the functions of this agency? Those can be hard for courts to come to grips with. It's really more Congress's job to monitor that side of administration. I have a short essay with two co-authors that talks a bit about this. It's on SSRN, but called Appropriations Presidentialism. I mean, the president is trying to kind of really push back on the law, and that's going to lead to a lot of court challenges. But as you're already seeing, there are a lot of open questions about what courts can do, about how the law works in this area. But even beyond that, there are kind of problems of institutional competence that mean courts can't be a complete solution if Congress is going to be so passive.
Another question we have here is how this all relates to reductions in government workforce. Is that the same question as an impoundment question, or is it distinct?
Well, I could take a first crack. I mean, I think there is a process you're supposed to follow there as well. And if they're not doing that, then that could be unlawful. In terms of impoundment, I think in principle, if Congress appropriates a sum for agency staffing, then under the Impoundment Control Act, the idea is like, we figured out what resource level you need, and you're supposed to prudently employ those funds to carry out the agency's functions. So if you're just cutting staff and not spending that money, I think that certainly could be an impoundment. There was a Government Accountability Office opinion a couple years ago where someone raised this as a concern, and they thought it wasn't, if I remember right, it wasn't valid in that context, but kind of accepted the general theory. So staffing levels, it could be an impoundment if you're cutting staff, and that means you're not spending money to carry out agency activities that Congress wanted you to spend.
We are getting close to the hour, so perhaps I should just ask all of you if you have some closing thoughts. Perhaps we can go backwards from our opening and start with Phil.
Sure. I just go back to Gregg's earlier question about why should people care about this, and I think we're seeing a moment of extraordinary executive assertion of power in general, and this is a very important aspect of how that's playing out, right? This is the one that our founding fathers were, in some sense, most focused on, right? The idea that, when it comes to taxing and figuring out what happens to government funds, it can't just be the decision of a king who doesn't necessarily have your best interest at heart. You need your representatives intimately involved in that process to make sure that the people's interests are represented. And so I think the Trump administration, by talking about how it's just cutting waste, fraud, and abuse, well, that sounds very benign, and how it's got the mandate of the American people, and how could you possibly stand in its way when all it wants to do is stand up for the American people's interest? That makes a good selling line, but in practice, they're using that as a license to do whatever they like. And that fundamentally rebalances power in our constitutional separation of powers toward the presidency. And frankly, we're already leaning too heavily in that before this administration ever showed up. So I would say we ought to look at this not just as some sort of question of our fiscal processes, which maybe do make people's eyes glaze over, but as a matter of where power lies in our constitutional system.
Thank you, Phil. Billy.
I think what I would add to that, just going back to the survey of the history of this issue earlier, is just to underscore how much of a break this administration's actions are from how past presidents have interacted with Congress's spending laws and executed appropriations laws. And I think to one of the points that Phil raised earlier about kind of the obscurity of some of these actions. There's DOJ cutting funds, there are agencies canceling grant awards and contracts. There are instances where, sort of separate from those things, money is being withheld from like Radio Free Asia or for the National Endowment for Democracy or other, folks to whom appropriated funds are, statutorily directed. And I think, however we call these things, I think the obscurity of like what exactly is happening is part of the way that the administration is exercising power here, and the lack of clarity around, whether it's this theory of an inherent power to impound or some other theory is part of the point here, and is, I think, part of the difficulty that litigants, Congress, civil society groups are grappling with.
And Zach.
Yeah, well, I agree with all that. I think, the power of the purse has really been understood to be the central legislative prerogative going way back. The American Revolutionary War ended because Parliament was no longer willing to continue funding the effort. So goes even before, it's rooted in British and colonial practice, and the framers certainly wanted to carry forward. And as I was saying earlier, I think it's particularly important in the modern context where Congress has delegated a lot of authority to the executive branch, and it's through this funding mechanism that it maintains ongoing checks and balances. But I also, just more generally, to pick up on some of what Phil was saying, we've got this polarized dynamic where presidents want to do big, aggressive, ambitious things, but they're not really necessarily broadly representative in doing that. And I think in that context, it's really important to have this push and pull so that we get policies that are more representative of overall public opinion rather than just a narrow partisan agenda. And I think the Trump administration is building on a pre-existing trend, but they're being really uniquely aggressive in pushing what can be done with unilateral executive action. And I think that's just not a good way to run a country with so much diversity of opinion and so many complex problems, where we need more kind of buy-in from everyone about how to move forward.
Well, thank you. And we're at the hour, but Professor Zachary Price from UC San Francisco, Billy Ford, Protect Democracy, and Dr. Philip Wallach from AEI. I'm really grateful to the three of you for joining us today. This was a great discussion. A reminder to everybody, this has been taped. It will be available on our YouTube channel. You can go back and watch it again, share it with friends. I apologize, I did not get to all of your questions. There's some good ones there, including about the non-delegation doctrine, which is maybe an entire different conversation for another event. But thank you all again. A reminder too, our members make this possible. If you're not yet a member, please consider joining at the Society for the Rule of Law.org. Follow us on YouTube, Twitter, Blue Sky, and LinkedIn, where we are constantly updating folks about our activities and our future program. Thank you all very much, and have a wonderful rest of the week.